Welcome everyone to the Liberty Fringe at the Conservative Party Conference of 2012. We have had many a happy meeting, debate, discussion at this conference over the years. And let's not forget that the Conservative Party in opposition made very many important and principled stands on issues of fundamental rights and freedoms.
We have, as you'll recall, got rid or changed substantially the law on DNA and fingerprints. In the Freedoms Act, we've introduced checks on schools taking biometric details of pupils without parental consent. We've altered the rules and law on CCTV and brought in a video surveillance commissioner and opportunity to look at that. We've introduced the requirement for judicial approval for communications data by local authorities obtaining it. We have, and I must say I think this is one of the things I really feel really happiest about, dealt the death blow to Section 44 of the Terrorism Act. And it is noteworthy that having done it and having been told for years by our predecessors that this was an essential tool, in fact the number of people stopped and searched has collapsed. And there is no sign that we are any more endangered as a result of the removal of this draconian piece of arbitrary power that we had given to the police. And I'm really proud of that. As a lawyer, I can't escape the fact that the Justice and Security Bill and the introduction of closed material proceedings and their possible introduction is a very controversial topic. I was brought up as a lawyer to believe in equality of arms and to believe in the autorem partem rule, that you hear the other side and everybody has access to the information on which civil litigation is conducted. And whilst these changes don't affect the criminal law, the proposals that have been brought in are a very substantial intrusion on that principle.
From Liberty's perspective, it is a little sad to hear from the coalition government a defence of secret courts based on Guantanamo litigation, which was of course about the worst excesses of past government. And I've been nobbled by various gentlemen in dark suits from the agencies before and since the election about Guantanamo and how embarrassed they were about their litigation. And guess what? The best way to avoid expensive, time-consuming, embarrassing civil litigation about internments and torture is not to get stuck in it.
May I just echo that 150%?
No matter how I read the provisions of the Justice and Security Bill as it stands, I do have a few worries about it and concerns, because it's like nails down a blackboard to my instincts. Because I accept that in the real world, it's not always possible to let everything hang out. That is why we have in-camera hearings, it's why we have public interest immunity already, it's why we have confidentiality rings, it's why we have CMP already in some courts, which the attorney has laid out. It's so that you can deal with cases where you do have highly sensitive evidence and you can still deliver as fair a trial as possible. We should sit up and pay attention when the people who've been working within the system, the special advocates, have expressed concerns about extending the CMPs and who have expressed concerns about the way that the system is working. Now, whatever you feel about the US-UK extradition treaty, there surely can be no question about the need for proportionality and judicial oversight in the European arrest warrant. I do think that we are keenly awaiting a response to the Baker report. And of course, the Baba Ahmed decision also raises the question of forum. As we move more and more to globalised and internet-based cross-crime and cross-jurisdictional prosecutions are going to become the norm. And we have to ask ourselves where the threshold lies for an extraditable crime where that person in question has never entered the requesting state.
In great detail, but I would just draw attention to two things that would be worrying to someone who believed in the notion of the rule of law. The first is with regard to the Justice and Security Bill, with the notion of evidence. And we ask ourselves the question, what is evidence? It's an interesting question. Can there be such a thing as evidence that is not actually available to both sides in a legal case? Evidence isn't just, as it were, information. It's something that is achieved in a public, if I was being philosophically pompous, I'd call it a public epistemic, a shared epistemic status. And therefore, evidence in that sense cannot be withheld from one side of the argument and remain evidence.
I just want one further point about the intelligence services and these secret courts. I've been a journalist for 20 years. I don't believe stuff which comes from the intelligence services. They fabricate it. And it's been proven that they fabricate it, unfortunately. And in connection with the Iraq invasion and other matters. And so I'm just not prepared to. I find it extraordinary, the idea that they should be able to have some privileged relationship with a judge